Committee on Workforce Protections will come to order. Welcome, everyone. I note that a quorum is present. The subcommittee is meeting today to hear testimony on second-class workers, assessing H-2 visa programs' impact on workers. This is a hybrid hearing pursuant to House Resolution 8 and the regulations thereto. All microphones, both in the room and on the platform, will be kept muted as a general rule to avoid unnecessary background noise. Members and witnesses will be responsible for unmuting themselves when they're recognized to speak or when they wish to seek recognition. When members wish to speak or seek recognition, they should unmute themselves and allow a pause of 2 seconds to ensure that the microphone picks up their speech. I also ask that members please identify themselves before they speak. Members who are participating in person should not be logged onto the remote platform or should not be logged onto the remote platform in order to avoid feedback, echoes, and distortion. Members participating remotely shall be considered present in the proceeding when they are visible on camera, and they shall be considered not present when they are not visible on camera. The only exception to this is that if they are experiencing technical difficulty, and they should inform the committee staff of such difficulty. If any member experiences technical difficulty during the hearing, you should stay connected on the platform. Make sure you're muted and use your phone to immediately call the committee's IT director, whose number was provided in advance. Should the chair need to step away for any reason, another majority member is hereby authorized to assume the gavel in the chair's absence. In order to ensure that the committee's 5-minute rule is adhered to, staff will be keeping track of time using the committee's digital timer on the remote platform. For members participating in person, the timer will be broadcast in the committee room on the television monitor as part of the platform gallery view and visible in its own thumbnail window. The committee room timer will not be in use. For members participating remotely, this will be visible in gallery view on its own thumbnail window on the remote platform. Members are asked to wrap up promptly when their time has expired. And finally, while the recent guidance from the Office of the Attending Physician has made mask wearing optional at this time, please know that we have in our midst at both the member and staff levels, individuals who are immune compromised and who have immediate family members who are immune compromised, as well as who are not vaccinated, either due to medical reasons or because the vaccine is not yet available to children under 6 months of age. And therefore, the committee strongly recommends that masks continue to be worn out of concern for the safety of unvaccinated and immune compromised committee members and staff and their families. Pursuant to Committee Rule 8C, opening statements are limited to the chair and the ranking member. This allows us to hear from our witnesses sooner, and it provides all members with adequate time to ask questions. I recognize myself now for the purpose of making an opening statement. Good morning. Today, we are meeting to discuss the important role temporary migrant workers, sometimes called guest workers, play in our economy and the critical need for increased accountability and worker protections. The H-2A and H-2B visa programs allow U.S. employers to bring foreign workers to the U.S. to fill temporary agriculture and non-agriculture jobs for which U.S. workers are not available. Tens of thousands of foreign citizens apply for admission to the United States each year under these H-2 programs, and applications are growing. And so are visa issuances. In fact, in 2019, agricultural visa issuances exceeded 200,000 for the first time since the beginning of the program. And according to the latest data, the combined number of H-2A and H-2B visa issued was just under 353,000. Workers apply for H-2 visas to achieve economic opportunity, to escape poor working conditions and ultimately with a hope that their employment can lead to a better life in America. Regrettably, the programs too often fail to deliver on these goals. Instead, as our witness, Mr. Daniel Costa, put it, when it comes to H-2A and H-2B programs, the U.S. government is failing to meet these basic standards and provide these basic rights to workers. For example, temporary migrant workers can be charged exorbitant fees by recruiters for the opportunity to work temporarily in the U.S. Meanwhile, these recruiters are rarely held liable for the recruitment fees and abusive tactics. In a recent case, Operation Blooming Onion, prosecutors charged H-2A owners, contractors, and recruiters while selling for trading workers, requiring them to dig onions with their bare hands, paying 20 cents for each bucket harvested, and threatening the victims with guns and violence to keep them in line. Allegations also included kidnapping, rape, and threats of violence and death to family members. The victims were allegedly held in cramped, unsanitary, fenced work camps to prevent them from escaping, while little or no food, limited plumbing, and without safe water. At least 2 of the workers died because of these workplace conditions. This is not economic opportunity. It's not a chance for a better life. This is federal prosecutors, as federal prosecutors have described, is modern day slavery. Problems with this program affect workers in communities across the country. My home state of North Carolina is one of top 5 employers of H-2A workers. The Midwest Center for Investigative Reporting spoke to many immigrant laborers who have become physically and mentally ill working North Carolina's tobacco fields. One H-2A worker said, "I have seen my coworkers suffer from tobacco sickness. A lot of them get allergies, others get insomnia, vomiting, many get dehydrated. And there were times when the workers would need to go for IV drips at local clinics." Baltimore Valesquez, co-founder and president of the Farm Labor Organizing Committee, told the reporters, no worker in his right mind is going to complain. There's no way to protect the workers from complaints and to protect them from retaliation. Cases like Operation Blooming Onion are the direct result of extraordinary power imbalance between workers and employers in this type of visa program. Unlike workers who are U.S. citizens or permanent residents, H-2 workers cannot easily switch jobs or employers, which is one of the most fundamental protections of a competitive labor market. Instead, when confronted with an unscrupulous employer, they are too often forced to remain silent rather than speak up and risk retaliation or deportation. Exploiting foreign workers also hurts American workers. We all know that when workers have more power in the workplace, they have higher wages, better benefits, and safer workplaces. By contrast, exploiting workers leads to degrading wages and working conditions for all workers in the same occupation. Moreover, we have a real example of H-2A workers displacing an existing local workforce. As Mr. Ty Pinkins will testify, local Black workers have been the backbone of the Mississippi Delta farm economy for generations, and they would like to continue these jobs. However, the same local farmers who employed these workers for decades are now filling the jobs with H-2A workers. These employers also paid the H-2A workers significantly more money for the same or similar work previously done by local Black workers. We should agree that all workers, both foreign and American, deserve to be treated with dignity and respect. As such, we have a responsibility to reform the H-2 visa program. So today, I look forward to discussing several proposed solutions focused on prohibiting discrimination, holding recruiters and employers liable for abuses, mandating the use of prevailing wages and strong labor standards, providing a path to citizenship, and protecting workers from retaliation. These important steps, coupled with other critical provisions to increase worker protections and accountability, will ensure that workers can succeed in fair working conditions. So thank you to our witnesses for joining us today. I look forward to our discussion. I now recognize our distinguished ranking member for the purpose of making an opening statement. Keller?
Morning. Thank you to the witnesses for being here today. Hundreds of thousands of illegal aliens are pouring across the border every month because of President Biden's open border policies. Yet Democrats are holding a hearing about nuances of legal temporary guest worker programs. This is a case of missing the forest through the trees. Discussing reforms to the H-2 programs make little sense when the border is open and immigration laws aren't enforced. H-2 employers following the rules cannot compete with bad actors hiring illegal aliens who are coming into the country in record numbers. Employers need the ability to bring in temporary guest workers when no U.S. workers are available. Although the H-2 programs should be more efficient and easier for employers to use, these programs are certainly in need of reforms, but these programs are far from our primary concern. In 2021, Border Patrol agents arrested almost 2 million aliens trying to cross the border illegally. That does not count the 700,000 aliens who entered the country without being apprehended since President Biden took office. In May alone, almost 240,000 aliens were encountered at the southern border, an historic high. What caused the massive influx of illegal crossings and dangerous conditions? President Biden's open border policies. Ending the Trump-era Remain in Mexico policy, suspending asylum agreements with the Northern Triangle countries, and stopping construction of the border wall. President Biden has done everything in his power to make our border less secure and Americans less safe. Under the catch and release policy, over 1 million aliens have been allowed to enter the country with little hope that they will show up for their asylum hearings that won't be scheduled for 2 to 3 years because of a massive backlog. We also recently discovered that sponsors of unaccompanied alien children who sometimes house and care for these children do not need to be in the United States lawfully themselves, raising serious questions about our vetting processes. And many of these didn't get the unaccompanied minors to the required legal proceedings. Both the Biden administration's rhetoric and policies are creating incentives for more aliens to flood the border. For example, instead of trying to secure the border, the Biden administration is fighting to end Title 42, which could increase border encounters from approximately 7,700 a day to up to $18,000 people per day. The Biden administration's policies are enriching human traffickers and drug cartels. The Sinaloa cartel, for example, is making a fortune smuggling drugs that are killing Americans. 90% of fentanyl enters the U.S. from the southern border, and it is now the leading cause of death among Americans ages 18 to 45. These ruthless smugglers have also been known to abandon children in the desert, place aliens in unsafe conditions, and abuse women and children in the process. The Biden administration's decision to ignore immigration laws, bolstered by congressional Democrats' endorsement of this behavior, makes this topic of this hearing misguided at best. President Biden's willful decision to ignore immigration laws makes every American less safe. Until the border is secure, the wall is built, and our immigration laws are being enforced, we will not be able to have a meaningful discussion about reforming the H-2 work visa programs. Thank you, and I yield back.
Thank you, Ms. Keller. Without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on August 3rd. I will now introduce the witnesses. Mr. Daniel Costa is the Director of Immigration Law and Policy Research at the Economic Policy Institute and a visiting scholar at the Global Migration Center at the University of California. Mr. Costa is an expert on H-2 visa programs and has extensive knowledge of how the programs operate and current issues within both programs. Ms. Teresa Romero is the president of the United Farm Workers. The United Farm Workers is the largest farm worker labor union in the country. And in her role as president, Ms. Romero can speak to the issues facing H-2A and other farm workers. Mr. Leon Sakara is an attorney in private practice and provides advice and counsel to clients who employ H-2A and H-2B guest workers. Mrs. Sakara has extensive knowledge of the H-2A and H-2B programs and has previously served as an assistant deputy secretary of the Department of Labor under the George W. Bush administration. Mr. Ty Pinkins is a consumer protection associate at the Mississippi Center for Justice. Mr. Pinkins represents Black farmers in the Mississippi Delta who've been displaced by H-2 workers employed by local growers, and he will speak in detail on how the misuse of H-2 programs affects local workers and economies. We appreciate the witnesses for participating today, and we look forward to your testimony. I do want to remind the witnesses that we've read your written statements and they will appear in full in the hearing record. And pursuant to Committee Rule 8D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. But before you begin your testimony, please remember to unmute your microphone. During your testimony, staff will be keeping track of time, and the timer is visible to you at the witness table. So please be attentive to the time, wrap up when your time is over, and remute your microphone. We will let all of the witnesses make their presentations before we move to member questions. When asking a question, please remember to unmute your microphone. The witnesses are aware of their responsibility to provide accurate information to the subcommittee, and therefore we will proceed with their testimony. I want to first recognize Daniel Costa. You're recognized for 5 minutes.
Thank you. Good morning, Madam Chair Adams, Chairman Scott, Ranking Member Keller, and other distinguished members of the subcommittee and committee. Considering my background and the issues I care about, it is a particularly great honor to be before the subcommittee today, and I'm grateful to the committee that they've decided to examine the issues before us. I grew up in and currently live in the agricultural heartland of California in the Great Central Valley. My mom, when she came to the United States from Mexico, first worked there in a poultry plant, meat processing being one of the main H-2B occupations. And in fact, she still worked there while she was pregnant with me. My entire dad's side of the family, when they immigrated to the US, almost all worked and lived on dairies, milking cows in the San Joaquin Valley. All of that is just to say that I don't come at this issue from the perspective of just someone who is a lawyer and a researcher. I feel deeply connected to these issues and have been around them almost all my life and care deeply about this work, and mainly just want to improve conditions for migrant workers and American workers in all of the industries that we're going to discuss today. Thus, I hope my testimony will be useful to the committee. Since we're here today to discuss H-2A and H-2B, two of the US's most discussed and sometimes controversial visa programs, first I'd like to start off by saying a few words about those programs in general, which I've studied and written about for over a dozen years. Most importantly, I want to discuss why they're flawed and need to be fixed by Congress and federal agencies, and why they are not, as presently constituted, fair labor migration pathways for workers. Temporary work visa programs are an instrument ultimately used to deliver migrant workers to employers, but without having to afford them equal rights, dignity, or the opportunity to integrate and participate fully in political life. While such programs may serve as important pathways for migrants to come to the United States, the numerous programmatic flaws that undermine labor standards and leave migrant workers vulnerable to abuses and even human trafficking clearly demonstrate a need for dramatic improvements. So what are the major flaws in temporary work visa programs? Here's a quick list. Illegal recruitment fees and debt bondage are common. Temporary work visa programs permit employers to circumvent U.S. anti-discrimination laws and segregate the workforce. The visa status of workers is usually tied to their employer, thus chilling labor rights, preventing job mobility, and enabling employer lawbreaking. Temporary migrant workers are often legally underpaid. Oversight is lacking, leaving workers unprotected. Most temporary migrant workers cannot transition to a permanent immigrant status. In the few programs that offer that pathway, it is controlled by employers. And finally, many temporary migrant workers are separated from their families while they're employed in the United States. These temporary work visa programs can and should be reformed to comport with universal human rights and labor rights standards. Considering that a record number of temporary migrant workers are now employed in the United States, more than 2 million, with many performing jobs that are now deemed quote unquote essential, the need to protect these workers has never been more acute. So now just a few words about the H-2A and H-2B programs specifically. Employers and defenders of the H-2A and H-2B programs as presently constituted will tell you that you shouldn't worry about or think about H-2B or H-2A because the workers represent such a small share of the workforce, and that anyways, no American workers want to work in agriculture, landscaping, hospitality. They'll say, for example, that H-2B is only 66,000 workers in a labor market of 160 million. Therefore, it's a drop in the bucket in terms of the labor force. First of all, the reality is that the programs have grown rapidly. The number of H-2A workers was 300,000 last year, and the H-2B program is now more than twice the size of the annual cap. Well, if it were actually the case that we were just talking about 300,000 H-2A or 150,000 H-2B workers, all of whom had rights and could go work for whichever employer they wanted to and had a path to citizenship, then yes, there would be many fewer concerns about these programs. But instead, the reality is that H-2 workers don't have rights and can't go work for whichever employer will offer the best conditions and highest pay. Instead, the migrant workers in the H-2 programs are recruited and hired by employers that control their immigration status and job opportunities. And they go into a small, closed universe of occupations and employers. Nearly all H-2A workers are employed in crops, and there's only 9,000 H-2A employers. And nearly all H-2B workers are employed in just 10 occupations, and there's only 5,000 H-2B employers. That's 5,000 employers out of a labor market with about 11 million establishments nationwide. That is to say, workplaces nationwide. So it's just a very tiny sliver of the labor market that those workers can actually participate in. That means that who H-2 workers can work for and where they can work is severely limited. And they have virtually no say over it, and they have no power once they get to that workplace. And we know from wage and hour enforcement data that wage theft is all too common in the industries that H-2 workers are recruited into. What's desperately needed then is a way for workers to come forward and have power to report abuses without fear, so they can be paid fairly and treated with dignity, and to not have to fear losing their paycheck or their immigration status. Part of that is also having labor standards enforcement agencies that are adequately funded and staffed so they can accomplish their mission of protecting wages and working conditions, as well as holding employers accountable when they break the law. And finally, migrant workers in the H-2 programs need to have access to a quick path to permanent residence and citizenship, and to not have to labor in a precarious and temporary immigration status, sometimes for decades, where they can be easily robbed and exploited by employers and recruiters because of that status. With that, I'll conclude, and I look forward to any questions from the committee.
Thank you, Mr. Costa. We'll now hear from Teresa Romero. You have 5 minutes, ma'am.
Chair Adams, Ranking Member Keller, Chair Scott, Ranking Member Fox, and distinguished members of the subcommittee, thank you for the opportunity to testify today. My name is Teresa Romero, and I am the president of the United Farm Workers, the UFW. Today, I'm testifying on behalf of the UFW and the UFW Foundation. We're proud to represent farm workers. Every day, farm workers work in difficult and dangerous conditions to feed our nation. They care for dairy cows to ensure our milk production, tend livestock for our meat, and plant and tend harvest fruits and vegetables for our daily nourishment. Without farm workers, our food industry and security would collapse. We welcome this hearing on the H-2A visa programs. We are deeply troubled by the many abuses of the H-2A and domestic workers associated with the H-2A program, and believe this hearing provides an opportunity to expose the inherently flawed nature of this program. The challenges of the H-2A program cannot be understood in isolation, but instead must be considered in the context of our broken immigration system, discriminatory labor law exclusions, and widespread violations of farm workers' limited rights. Unfortunately, the H-2A regulations are inadequate to protect both H-2A and domestic workers. There is a tremendous power imbalance between H-2A workers and their employers. As I have explained in my written testimony, H-2A farm workers rely on their employer for their visa, housing, transportation, and will lose their opportunity to work in the U.S. if they lose their job. Challenges facing H-2A and domestic workers begin during the recruitment process, with widespread fraud, illegal fees, gender and age discrimination, and more. Recruitment fees and other travel costs are as well as coercion, leave workers indebted and reluctant to enforce their workplace rights, as they are desperate to repay their debt and fear other possible repercussions to them and to their families. The Operation Blooming Onion shows the H-2A program presents tremendous dangers farm workers. The allegations in the case are devastating and include criminal charges for multiple deaths, rape, and forced labor. This case demonstrates the inherent flaws of the H-2A program and the government's inability to enforce the H-2A, the modest H-2A protections that do exist. The government still does not know many potential victims there may be. The violations that were exposed are not isolated instances. Additional government investigations and indictments, Polaris's data, and our own experiences make that crystal clear. Our government is running a program with multiple workplace abuses, deaths, and rapes. The H-2A program must not be allowed to continue as is. Congress and administration have the obligation to make meaningful reforms. First, Congress must pass the urgently needed legislation, beginning with the Farm Workforce Modernization Act, a bipartisan compromise that will help stabilize agricultural labor system and address some of the H-2A program's flaws. We thank the many subcommittee members who supported this bill. In addition, Congress must end the discriminatory treatment of agricultural workers under the Fair Labor Standards Act by passing the Fairness for Farm Workers Act. DOL has announced work to begin creating OSHA heat standards, but the process is lengthy and farm workers need protections from heat now. In the last few years, at least 3 H-2A workers have died in Georgia from heat. Miguel Angel, an H-2A worker in Georgia, asked for help, but no one's provided until it was too late. Congress must pass the Asuncion Valdivia Heat Illness and Fatality Prevention Act to protect workers from extreme heat. The administration must engage in additional rulemaking to strengthen protections and ensure accountability in the H-2A program. This rulemaking must ensure stronger and effective recruitment and anti-trafficking protections, joint employer liability for farm labor contractors and fixed site employers, and freedom of association and collective bargaining agreements at H-2A workplaces. These protections are key to ensuring that workers have the tools necessary to assert the protections, including the ability to raise their voices without fear of retaliation or blacklisting. Let's work together to make sure that we can continue feeding America. Thank you very much.
And thank you, Ms. Romero. I want to recognize now Leon Sakara. Sakara? Yeah.
Thank you. Good morning, Chairwoman Adams, Ranking Member Keller, and members of the committee. I appreciate the opportunity to testify today. I regularly advise employers on the complexities of the H-2A and H-2B programs and represent them in the course of government audits, investigations, and litigation. I'm testifying today in my personal capacity and not on behalf of any client. The H-2A and H-2B programs and the employers who utilize them are highly regulated by numerous federal and state agencies. Employers of guest workers are overwhelmingly good people who treat their employees with respect and gratitude and who do their best to follow the law. It's important to recognize that these guest worker programs were designed by Congress to be, first and foremost, U.S. worker protection programs. That is, no employer can hire a temporary foreign worker unless the federal government first determines that employment of the foreign worker will not harm the wages and working conditions of U.S. workers. That rigorous determination process takes several months to complete and requires the employer to receive approval from 3 federal agencies and at least 1 state agency. The approval process also requires, among other things, that the employer pay a special government-mandated wage rate, provide other benefits, and hire any able U.S. worker who wants the job. Once an application is approved, and sometimes even before, employers are routinely subjected to compliance audits and investigations by numerous state and federal agencies to ensure that they are complying with the rules of the program. In conjunction with the extensive enforcement efforts, federal agencies also provide comprehensive outreach and educational materials advising workers of their rights. These efforts begin before the workers even leave their home country. At the U.S. consulate abroad, workers are interviewed by State Department officials to ensure that they have received required information from the employer and that the workers are provided with anti-trafficking information, including a phone hotline to report any issues they encounter during their employment. When workers arrive in the United States, these efforts continue. Workers will see specific government-mandated posters at their worksite, advising them of applicable protections and providing, again, a phone hotline to report any concerns to the Department of Labor. In addition, the Department of Labor and numerous state agencies regularly conduct site visits to meet with workers and educate them about their rights. Attached to my written testimony is a list of just some of the many educational brochures and pamphlets distributed by government agencies to guest workers. On top of all the government efforts to educate and protect workers, there are also countless nonprofit groups, advocacy organizations, labor unions, and legal advocacy groups that ensure guest workers are protected. In fact, in the H-2A program, these advocates are even guaranteed access to farm housing to meet with workers where they live. Despite all of these efforts, there will be employers that do not follow the requirements of these programs. When that happens, no one will dispute that those employers should be held liable for violations and affected workers should be made whole. But Department of Labor enforcement data confirms that only a small fraction of employers violate the guest worker program requirements. For example, in 2019, the department approved more than 12,000 H-2A applications. That same year, there were 431 enforcement cases by the Department of Labor that involved an H-2A violation. That's just 3% of all approved applications. And based on my experience, most H-2A violations involve technical and paperwork violations that have no impact on worker wages and working conditions. Certainly, egregious violations occur from time to time, but the Department of Labor's enforcement data confirms those cases are the exception and not the rule. I'll conclude with one final point. H-2A and H-2B workers are critically important to the farms and seasonal businesses that rely on them. As I already noted, because the federal government approves the employment of every guest worker, their employment by definition cannot harm U.S. worker wages or working conditions. By contrast, the Department of Labor has recognized the biggest threat to U.S. worker wages actually comes from competition by large numbers of people who are illegally present in the country. Last year, about 350,000 guest workers entered the U.S. legally and returned home at the end of the season. But in just the past 8 months, more than 440,000 people are known to have illegally crossed the border without being apprehended. The H-2A and H-2B programs are not perfect. No government program is. And we should all be able to agree on reasonable measures to help improve these programs. But I would hope that we can also agree that the country's borders should be secure and that people coming to work in the United States should do so through an orderly and legal process that protects them and protects U.S. workers. Thank you again for the opportunity to testify, and I look forward to your questions.
Thank you. We'll now hear from Ty Pinkins. You have 5 minutes.
Chairman Adams, Ranking Member Keller, and members of the subcommittee, I'm pleased to appear before this committee. Thank you for the opportunity to speak with you today about the guest worker program and its impact on local workers. My name is Ty Pinkins. I'm a veteran, served 21 years in the Army. I'm a lawyer and Equal Justice Works Fellow at the Mississippi Center for Justice. But more important than all of that, I'm a son of the Mississippi Delta. My work as a lawyer today in the Delta focuses on ensuring low-income community members have access to legal representation, which they could not afford if it were not for services offered by the Mississippi Center for Justice. And that is certainly the case with regard to local farm workers. I'm here today because across the Mississippi Delta, farm owners participating in the H-2A program are in blatant violation of the promises they made to the federal government. The H-2A program has grown exponentially across the nation in recent years. There has been relatively little public discussion of what impact this growth has had on farming communities. Many have simply accepted the assurances of agribusinesses that the H-2A program needs to be expanded and streamlined because, according to the H-2A proponents, there simply aren't any Americans left willing and able to perform the demanding physical labor required of most farm jobs. I'm here to tell you that this is a myth. While the number of Americans working in agriculture has declined, there are still many areas across the country where U.S. citizens depend on farm work for their livelihoods, and the Mississippi Delta is one of them. Agriculture remains the dominant industry in the Delta, as well as the major source of jobs for local community members, the majority of whom are Black. Each morning, thousands of Delta residents, almost all of them citizens, go to work at those demanding farm labor jobs. As in generations past, their efforts are essential to keeping the Delta the productive agriculture area that it has been for centuries. In many cases, those local farm workers are carrying forward a family legacy because their parents and grandparents worked these same fields for generations. A May 28th article in the New York Times, as well as a lengthy article recently published in the Mississippi Today, described how the rapid expansion of the H-2A program is transforming the farm labor market in the Mississippi in much the same fashion as it is across the country. These changes have been extremely detrimental to local farm workers. Despite all the laws and regulations designed to protect American workers against unfair competition from H-2A workers, the local farm workers in the Delta have been displaced as area farmers each year import more and more foreign workers. Absent major changes in the way the H-2A program is administered and its rules enforced, there won't be another American generation of local black farm workers in the Delta. Instead, their jobs will have all gone to H-2A workers who are far more susceptible to employee abuse. In accordance with the Department of Labor regulations, farm owners make 3 specific promises to the federal government when applying to participate in the H-2A program. First, no H-2A should be admitted to the U.S. to fill a job unless no qualified U.S. worker is available. In order to further this policy, when requesting to participate in the H-2A program, farm owners must promise the federal government that they will contact former U.S. workers they employed during the previous farming season and invite them to return to the job before those farm owners reach out to foreign H-2A workers. Furthermore, farm owners must put forth at least the same kind and degree of effort to recruit U.S. workers to fill those positions as they do to hire foreign H-2A workers. Second, farm owners who do in fact bring in H-2A workers must pay them what's called the adverse effect wage rate, which differs by state and is subject to change each year. Mississippi's adverse effect wage rate for H-2A farms is $12.45 an hour. And third, to the extent H-2A workers are employed, their wages and working conditions cannot undermine those of local American farm workers, meaning business owners participating in the H-2A program promise the federal government that if they employ an H-2A worker and a U.S. local worker is performing the same job function, the employer must provide to the U.S. worker at least the same benefits, wages, and working conditions that are being provided to the H-2A workers. Many of the dozens of farms throughout the Delta participating in the H-2A program employ a range of discriminatory practices against local black farm workers. On behalf of several Delta farm workers, the Mississippi Center for Justice and Southern Migrant Legal Services have filed suits against several Delta farms for, among other things, discriminatory wage practices. With that, I'll conclude my comments, and thank you for any questions that you may have.
Thank you, Mr. Pinkins. Under Committee Rule 9A, we now question witnesses under the 5-minute rule. I'll be recognizing subcommittee members in seniority order. Again, to ensure that the members' 5-minute rule is adhered to, staff will be keeping track of time. Please be attentive to time, wrap up when your time is over, and your microphone. As chair, I now recognize myself for 5 minutes. Mr. Pinkins, Mr. Guerra's testimony downplays the impact H-2 workers have on U.S. workers. Specifically on page 5 of his written testimony, he states, and I quote, "Their employment does not harm U.S. workers." Do you think that local farm workers in the Mississippi Delta would agree?
No, I think they would certainly disagree. Downplaying the impact this has on U.S. workers ignores a few things. While the national unemployment rate sits at 3.2%, the unemployment rate in some of the poorest counties in the Mississippi Delta hovers around 14%. Additionally, the poverty rate in some Mississippi counties is as high as 40%. When you add that to the fact that in many cases farm workers earning $7.25 an hour salary is the only income coming into a household of about 4 people, you understand the impact that this has on a single income household of that nature.
Okay, thank you, sir. Ms. Romero, in your testimony, you described the history of racism against farm workers in this country and how they've been excluded from basic labor protections. So what can be done by Congress to address these racist exclusions for farm workers?
Thank you very much, ma'am. The Farm Workforce Modernization Act would give the opportunity to farm workers to work and be here in this country. with a path to legalization. And we need to make sure that all the exclusions and protections for farm workers are considered to make sure that now we pass the Fairness for Farm Workers Act that will protect and give the same rights to these workers that other workers have. When you have, in most states where workers cannot earn overtime pay, it is just unfair. And we need to treat farm workers as we treat any other labor force in this country.
Thank you, ma'am. I want to submit for the record the AFL-CIO and farm worker justice statements related to H-12 visas. Without objection, so ordered. Thank you, ma'am. I'm going to recognize now, I've got some time, I'm going to yield it back, but I want to recognize the ranking member for questioning the witnesses. You're recognized, Mr.
Thank you. We cannot ignore the elephant in the room, which is that President Biden's border crisis is a man-made disaster. Illegal aliens and drugs are flooding into our country at record levels with no end in sight. The open border undermines the lawful guest worker programs we are discussing today. Mr. Sequeira, how does the current environment of an open border and unenforced immigration laws affect the H-2A and H-2B visa programs?
Thank you, Mr. Keller. I think there really are two impacts that come to mind. The first is that employers who go through all the trouble to apply and to legally hire workers through these guest worker programs and pay an enormous amount of money to consultants and attorneys, as well as the additional benefits and wages that have to be provided, end up being audited by the Department of Labor or other and nitpicked over small violations. Meanwhile, as workers flood across the border and are hired by other employers, they are rarely audited. And so employers generally in the program think that there's a real imbalance and an unfairness in the fact that they legally hire workers, yet all the enforcement efforts of the United States government are focused against them rather than others. And secondly, I would say, from the worker perspective, many workers who come legally on these programs, who see folks come in illegally and there are no repercussions for them, will oftentimes decide, well, why am I going through all the trouble to go get a visa if I can just come into the country illegally and work?
Okay. Also, Mr. Sequeira, we've heard today about bad actors in the H-2 programs. Based on your experience and on the available data, are most employers doing their best to comply with the extensive requirements of these programs?
In my experience, they are. Again, I do quite a bit of audit work, helping employers navigate audits by the various government agencies, and the overwhelming number of violations are inadvertent violations with no harm to workers' wages and working conditions. The programs are full of scores of technical violations and very minute, detailed obligations that have to be met, including having your federal employee ID number on a paycheck stub, for instance. So most of the violations are of that nature. I don't want to say that there are never serious violations. There certainly are. But the overwhelming majority of employers do their best to comply with the law and do so successfully.
And I would say the employers that are doing it properly want to make sure that the ones that are not and treating people poorly are held accountable.
Absolutely. The employers who rely on these programs to supplement their domestic workforce rely on these programs, and they want to continue to have access to them. And they've got no compassion for employers who flout the law and intentionally deprive their workers of their rights.
Okay. Also, Mr. Sequeira, the H-2 programs have wage requirements intended to ensure that H-2 workers do not negatively impact the wages of American workers. What are these requirements, and what does the research say about them?
Well, Congress designed the program specifically to ensure that U.S. workers would not be adversely affected, and that determination has to be made before an employer ever receives approval to hire these workers. So the Department of Labor assigns specific wages, both in H-2A and H-2B, that the department has determined are sufficient to not adversely affect U.S. workers. And there is no scholarship that shows otherwise. And again, because the basic premise of the program is you can't hire these workers unless you pay a wage that doesn't adversely affect them. There is, by definition, no adverse effect.
And the wages we're talking about are set by the federal government, not by the people hiring the H-2 individuals.
That's correct. And nationwide, they vary by region in the H-2A program, and nationwide, they average above $15 an hour. In the H-2B program, they vary by occupation and specific locality, but I have many clients that are paying H-2B wages of close to $20, and in some cases more.
So when people talk about these H-2A and H-2B individuals that are coming under these visas, getting mistreated and not paying a proper wage, that wage isn't set by them, it's set by the government.
That's exactly right. And most employers would tell you these wages that I'm required to pay are much higher than actually prevail in the local market area. Again, when you're faced with workers who have come into the country through other than legal means, the only requirement that the Department of Labor enforces is that people are paid the minimum wage, $7.25 an hour. So again, employers complain, I have to jump through all these hoops and legally hire workers, pay this high wage rate, but my competitors can pay $7.25 an hour.
Because we don't have our immigration laws enforced at our southern border, and we have people coming here illegally who are trafficked and taken advantage of.
In many cases, that's true, yes.
Gentlemen's time is
Thank you.
up. Thank you very much. I want to recognize now Ms. Sherpalis McCormick. You recognize, ma'am, 5 minutes.
Thank you, Madam Chair. My question's for Mr. Costa. Mr. Costa, Mr. Suquira points to the importance of the DOL's role in verifying that there is not an adequate supply of domestic workers. In your view, does the DOL have adequate resources to perform that role?
Well, there's the issue of resources and the mandate. The Office of Foreign Labor Certification, isn't actually verifying whether there are workers available or not. What they're doing is requiring employers to post job orders on a website, and they're not looking at real world labor market conditions when they do these sorts of assessments. And I think maybe most importantly, and I think Mr. Pinkins has spoken about this, after these jobs are posted, OFLC, the Office of Foreign Labor Certification, is not doing anything to check to make sure that employers actually hired the U.S. workers who applied. So that allows them to really just overlook the U.S. workforce.
Thank you. I have a second question for you. Mrs. Sequeira also stated that the H-2 workers are among the most protected and educated workers when it comes to their rights. Can you explain why, even given these aspects of the H-2 program, H-2 workers continue to face high levels of exploitation and workforce abuse?
Sure, even if we accept that these workers are briefed more than other workers about their rights, the reality is that the precarious immigration status that they have makes them vulnerable and makes them very unlikely to complain when something goes wrong on the job, when they're not paid fairly, when they have unsafe working conditions, because complaining can lead to getting fired, which leads to getting deported. And often these workers have paid illegal recruitment fees. And so I also think Mr. Sequeira has also kind of glossed over the fact that H-2A workers actually do get robbed of their wages quite a lot. In the report that I published, we looked at data going back from 2000 to 2019, and there was about 24 million stolen in back wages from H-2A workers, and these are workers who earned very low wages, and it was almost 42,000 workers who had their wages stolen over those years. That's wage and hour data. So the workers are vulnerable, and we actually published a study in 2015 showing that H-2 workers earn approximately the same wages as undocumented workers. So it's not so much that undocumented workers are undercutting the wages; it's that H-2A workers, even though they have this quote unquote legal status, they're still paid low wages. And why is that? Well, we think it's because they can't switch jobs. They can't take the skills that they learned to move to another job. So there's no wage gain. There's no wage premium for this quote unquote legal status.
Thank you so much. Madam Chair, I yield back the rest of my time.
Thank you very much. I want to recognize now the ranking member of the full committee, Young Lady of North Carolina, Representative Fox. Recognize, ma'am. 5 minutes.
Thank you, Madam Chair. I'd like to echo Subcommittee Ranking Member Keller's sentiments on the Biden border crisis. It's as if the president wants chaos at the border or simply doesn't care. The risks of human trafficking have been greatly increased because of the Biden administration's open border policies. Mr. Sequeira, would you agree that what is most urgent is to secure the southern border, and enforce our immigration laws to stop human trafficking?
Thank you, Ranking Member Fox. Yes, I would agree with that, and I think everyone would agree that the border should be secure and that the federal government should do more to ensure that there isn't extreme cases that we've seen all too recently at the border with human trafficking. And certainly the American workforce and American workers, I'm sure, would appreciate increased border enforcement so that they don't have to unfairly compete against workers who have not come to the country legally.
Well, I wish you were right in saying almost everyone, but obviously that isn't the case because the Biden administration is not enforcing the law. Many employers in North Carolina use the H-2 programs when no U.S. workers are available for these jobs. DOL regulations are intended to ensure that H-2 workers do not displace American workers. And I am very familiar with the rules and regulations and hear from employers all the time about this. So, Mr. Sequeira, what do the statute and regulations require before an employer is approved to receive H-2 workers, and what has been your experience with these regulations?
So there are very complex regulations by the Department of Labor and additionally through the Department of Homeland Security. But in essence, you can boil the process down to 4 major requirements. The Department of Labor has to determine that the employer is actually offering a temporary or seasonal job, that it's a bona fide business with a bona fide job on a temporary basis. They require the employer to pay a mandated wage. Again, the government sets the wage at a level that it thinks is sufficient to protect U.S. workers. Then that job opportunity has to be advertised to U.S. workers. They have first shot at these jobs. They have a right to the jobs. If they're qualified, you are required to hire a U.S. applicant. And even in the H-2A program, that requirement extends through the 50% point of the employment period. Even if you've already gone to the trouble of hiring hire H-2A workers because you had no U.S. workers show up, if a U.S. worker shows up halfway through the employment period, you're still required to hire them. So there are extensive requirements in the regulations that employers are required to adhere to, and by and large, they work.
Well, that's my understanding too. Contrary to what we just heard a few minutes ago, they're paying the wage that is set. And let's talk a little bit about that. DOL sets the wage rates for H-2A workers for different regions around the country. But many employers believe that these wage rates do not accurately reflect market conditions, and the unpredictable nature of the rates makes it challenging for employers to know what their labor costs will be. Mr. Sequeira, what are the flaws in how DOL calculates the H-2A wage rates?
I'm not sure we have enough time today to really discuss that in detail, but I would say in general terms, there are a lot of complaints with the way the wage data is collected and analyzed by USDA, and I think many of those can get into methodological problems and sample sizes. But the biggest problem in the end for employers is it's just simply not predictable. Employers and farmers don't know from one year to the next what their wage rate will be. In many areas of the country, the wages will go up 5, 10, sometimes even 20% from one year to the next. And you simply can't, particularly as a farmer who doesn't set the price for their crop, you can't effectively plan when you don't know what your labor costs are going to be.
I believe they went up about 17% recently, I know down in Florida, because I had some friends contact me about that. Well, we'd be happy to get from you an analysis that we could submit for the record, since we did not have enough time to go into answering that question a little more thoroughly, and I appreciate the fact that there's not enough time. So if you'll submit some material for us, we'll get it in the record. Thank you very much for your testimony. I yield back, Madam Chair.
Thank you, Ranking Member. So I want to recognize Mr. Norcross. Gentlemen, you have 5 minutes.
Thank you, Chair. Certainly appreciating to the ranking member for holding this hearing. It is, as I would describe, some of the best we have as a country and some of the worst. The idea of immigration is something that we all believe in, but certainly needs to be handled in a way that benefits everyone. Mr. Costa, one of the biggest flaws we've seen in the H-2B program is that the program tends to drive down wages for both immigration workers and those American workers. You know, we talk about the wages being defined by the Department of Labor through surveys and things like that. But can you please discuss what Congress, Department of Labor, and others are doing to ensure that these prevailing wages are properly paid to workers who have those H-2B visas and workers who already in the U.S. who work in these industries? How do they enforce it? Because we talk about enforcing the border, and I understand those discussions. But once they're here, we see such violations of prevailing wage. Can you talk about that a little bit?
Sure. I do think that just to state at the top that the wage rules should be improved. They should reflect the national standard because the H-2B statute sets a national standard for recruitment and for workers. And at present, it only reflects local wages. And so when you compare national H-2B average wages versus average wages for all workers, the H-2B wages, my research has shown, are usually lower. I think it's an easy fix. It just needs political will, and the administration could actually do that on their own. To your point about enforcement, I think that we do know that H-2B industries, where most H-2B workers are working, wage theft is very common amongst all workers in those top industries. Wage and hour division data show that pretty convincingly. When Wage and Hour does an investigation in a major H-2B industry, 80% of the time they find violations. And there was actually $1.8 billion in the past 20 years stolen from workers in those industries. That's all workers in the industries, not just H-2B. So I do think that the problem with enforcing the prevailing wage rule is that it's very difficult for H-2B workers to complain because of their precarious immigration status. They're very afraid to come forward because the employer finds out that they're complaining, they can just fire them. They become deportable. That makes it very difficult to stay in the country and pursue a claim, whether it's through Wage and Hour or whether it's through litigation. So that legal status really makes it hard for them to enforce their rights, and that's really the crux of the issue, I think.
Thank you. And let's be clear, the vast majority of employers do the right thing. Occasionally they'll make a mistake. We're not talking about that. We're talking about that 8 to 10% who literally undercut the entire industry. And that's where I want to go with my next question. When we start talking about those violations, those companies that get the H-2B guest worker visa year after year, there's dozens of them who have violations of wage and hour, health and safety, recruitment, yet they continue to get it. They get the next year and do the same thing over and over again. So the question is, in your opinion, the Department of Labor, do they properly fund and hold these bad actors accountable? How do we get rid of the bad guys, which helps all the good employers?
There's been some good reporting from BuzzFeed that showed that many violators of the H-2B and H-2B programs year after year continue to get workers, as you rightly suggest. I do think that something that would really help that hasn't been done is to have some sort of a front-end system to check whether or not employers have violated wage and hour laws, discrimination laws, civil rights laws, some sort of, maybe call it a TSA pre-check sort of a thing where employers submit their information and attest that they have not violated these laws in the past few years, and then have DOL verify it in some way. That way, wage and hour is vastly underfunded and understaffed, and are probably going to continue to be. So we need to have some way to weed out these bad actors before they actually get the visas, because as you mentioned, they can violate the program year after year and keep getting visas, really with no problem.
Madam Chairwoman, we should take a look at that. Again, we're not trying to overburden the 90% of folks who are doing the right thing. We're just trying to get rid of the bad actors and level the playing field. And with that, I yield back the balance of my time.
And thank you, sir. Let me yield to now Ms. Miller Meeks. You have 5 minutes, ma'am.
Thank you, Chairwoman. I thank our witnesses for being here. I'm in Iowa, former director of the Department of Public Health, military veteran, and a physician. So I've had the ability to take care of people across a broad spectrum of Iowa. I'm from Texas originally, however, so I'm very familiar with illegal immigration. And being in Iowa, I'm very familiar with H-2A and H-2B. I have visited employers who have people that come into the program. It's a very valuable program for us in agricultural communities. And I've also spoken with the workers at those farms and at those dairies who like the job that they're doing. I've been able to take them aside to try to get information individually from them about their working conditions as well. So as I said, a number of employers in my state use the H-2A and H-2B programs when no U.S. workers are available. We used to have teenagers who would go out into the fields, but that doesn't seem to be an occupation that they strive to do in the summer any longer. And while they appreciate the opportunity to fill jobs that are crucial for their operations, they're frustrated by the challenges, these are the employers, of navigating 3 different federal departments to secure workers, of complying with complex regulations. And let me also say that one of the bills I co-sponsored on legal immigration was passed this week through the House. And so we want to do what we can. And the doctors I've worked with who have come here legally think the system is unfair, that it takes them so long to become legal citizens where people are coming across our border with no repercussions. So, Mr. Seguera, what are the top reforms you'd make to improve these programs?
Thank you, Congresswoman. There are a number of reforms, and I think a number of reforms that, Mr. Costa and others and employers could probably agree on. The process is too long. Most employers complain that it's too bureaucratic. They have to start from the beginning every year. Again, many employers have a seasonal need every year. They have to apply to the program every year, but every year they have to start from scratch. The government should build a database, should have information to be able to quickly verify that they have a seasonal need, that they're offering the correct wage, and the process could be sped up rather than taking 3 months. It could certainly be cut down. Similarly, the Department of Labor determines all of these elements, that there's a temporary need, that the correct wage is being paid, et cetera. Once you clear that hurdle, you go to the Department of Homeland Security, and they determine all the same stuff over again. It's classic government bureaucracy and inefficiency that really, I think for the benefit of the workers, for the benefit of the employers, and for the benefit of the government and the taxpayer, there could be a simpler, more efficient way to do this.
Yeah, and having visited the border several times, and either witness, this is a yes or no question, are people coming across the border illegally even though they're processed and giving a return date for status, for refugee status? I mean, are those individuals vulnerable to extortion, wage theft, and human trafficking? Yes or no, Mr. Pinkins? Yes or no, please. I've got another question. Yes or no? Are these individuals coming across our border illegally subject to human trafficking, wage theft, vulnerabilities to extortion? Are they being utilized by the cartels? Yes or no? Thank you. Sir, yes or no?
I think absolutely.
Thank you. They are at risk. I appreciate it. It was a yes or no question. Mr. Seguera, in December 2021, the Department of Labor published a proposed rule to make changes to regulation used to determine adverse effect wage rates for H-2A workers. The proposed rule would continue using the Agriculture Department's Farm Labor Survey to determine the wage rates for a majority of field and livestock workers, but it would shift the remaining occupations to the Bureau of Labor Statistics Occupational Survey because DOL believes these jobs should receive higher wages. Are you concerned about the effects of wage rates on the proposed rules, and is this a push or pull for further illegal immigration?
Congressman, yes, I am concerned about that proposal, and virtually every farmer I have spoken to across the country is concerned about it because I think the Department of Labor fundamentally misunderstands the nature of agricultural labor. It is not a factory job that can be easily classified into a specific task. Most farm jobs involve doing multiple tasks over the course of the day, and how can you possibly apply, in the department's proposal, the absolute highest possible wage for any of those tasks applies to the entire period of employment? That will break the back of American farmers.
Thank you so much to our witnesses, and thank you, Chair. I yield back my time.
Thank you. I want to yield now to 5 minutes to Representative Jayapal. Recognize 5 minutes, ma'am.
Thank you very much, Madam Chair. My home state of Washington has one of the 5 largest populations of migrant farm workers in the country, and the contributions of farm workers to our communities and our economy simply cannot be overstated. In 2015, guest farm workers on pear, apple, and cherry operations alone contributing $619 million in economic activity in Washington state while putting food on the table for countless families across our state. It is absolutely essential that farm workers receive the same labor protections that federal laws afford to other workers. Migrant guest workers in particular need robust protections because their legal status is tied to their employer, which makes them especially vulnerable to exploitation and abuse. So, Ms. Romero, let me start with you. In your testimony, you mentioned some of the horrific labor abuses that were discovered during Operation Blooming Onion. In your experience, how widespread are abuses like those found in Operation Blooming Onion in the H-2A program, and how can Congress act to address these abuses?
Thank you very much, ma'am. Farm workers come to us every day telling us what the abuses are. In many cases, farm workers, when they come to work with an H-2A visa, their passport and their phones are taken by the recruiter because they want to make sure that the debt, the recruitment debt, is paid before they can send even money to home. I think the Farm Workforce Modernization Act would give legalization to these workers and would take away a big excuse to abuse, and not, in many cases, not to pay the workers for the work they have done. Workers have been sent home because without pay, saying we will be sending you your check, which they never received. The Farm Workforce Modernization Act would help here, but also it is important that we have the knowledge that these workers need somebody to help them represent their rights. And a collective bargaining agreement could do that for them. They would be there to make sure that they have a voice, that they have somebody to talk to when abuses are happening.
Well, let's talk about collective bargaining agreements. In an April 21st letter to Secretaries Mayorkas and Walsh, United Farm Workers urged the Department of Labor to require H-2A employers to have collective bargaining agreements with a labor union. So just with a yes or no, Ms. Romero, I want to quickly go through a list of all the ways that unions and collective bargaining can help farm workers. Do they increase wages?
Yes.
How about strengthening workplace safety?
Absolutely.
How about improving employer-provided food, transportation, and accommodations?
Yes.
Increasing enforcement of wage protections?
Yes.
Protecting workers from retaliation?
Absolutely.
So these are many of the benefits that would come forward if we were to have unions able to have a critical role in protecting workers from abuse. Every single day, migrant farm workers experience exploitation, fraud, and abuse. The H-2A program desperately needs increased oversight and enforcement, and we have to do our work and continue towards meaningful reform. Mr. Costa, what barriers are there to the enforcement of wage requirements and workplace safety regulations for H-2A farm workers?
I think that the main issue is the temporary precarious immigration status that H-2A workers have. It just makes it too difficult to come forward and avail themselves of the Labor Department or other agencies because they're worried about retaliation, which could lead to deportation, which would not allow them to earn back the money that they probably paid in terms of illegal recruitment fees just to get that temporary job.
And how would unions help build trust between workers and worker protection agencies, and to what effect?
Well, I think they could help them know their rights, help them bring complaints forward with less fear by having more information. And obviously, I think a collective bargaining agreement is one of the best protections that a worker can have.
Absolutely right. Thank you all for your testimony, and I yield back, Madam Chair.
Thank you very much. Let me yield to Mr. Good, you have 5 minutes.
Thank you, Madam Chairman. Mr. Segura, we have surrendered operational control of our border to Mexican crime cartels. This has been willful, it's been intentional, it's been purposeful by this administration. I continue to just be baffled by my friends across the aisle. Do they live in a fantasy land, in a land of denial, and pretend that it's not happening at the border? That the statistics coming from the administration, that there's been 3 million illegal crossings in a year and a half that are encountered by Border Patrol before they're released, the majority of them into the interior of our country, and then some 800,000 criminal gotaways, the ones who don't want to be taken into our social services, free healthcare, free education, free travel, with no requirement to appear in court. That 800,000, which I submit we will not know the full extent of the harm of those until eventually, when we seal the border, whether we cut off funding in 23, when we will absolutely have control of this Congress because the American people are rejecting these policies, or when we have the presidency as well in 25 and we can seal the border, then I think those who, the most devious actors will then begin to unleash their fury within the country when the border is secure. Why would they do it now when the border is open and their friends are coming across? And this administration, this majority, apparently does not care. And so while that's going on, at the same time, you know, and of course, record number in May, we had 240,000 illegal crossings that we know, the ones who were encountered. That doesn't count, again, the gotaways that are some estimated in the neighborhood of 15,000 a month or something like that. 10,000 a day now being apprehended, we're told, or encountered. Apprehended sounds like we're turning them back. We're not releasing most of them in the interior of the country. At the same time, and this ties into the H2 discussion, we're growing the welfare state. We have, and as an Assistant Secretary of Labor, I know you can appreciate this, we're growing the welfare state. We've removed the work requirements for subsistence. We're paying more people not to work. We're paying for housing. We're giving more provisions to folks who are not working, making them comfortable doing so. The labor participation rate is down. We've got 10 million open jobs in this country. And despite the Democrat majority's contempt for employers, contempt for small business owners, and their belief that left to themselves, their own devices, they would exploit and abuse their employees, they believe that about H-2As as well. I have met with many farm groups. I've visited many farms and agriculture employers in my district, and they treat these H-2A workers like family. There's a close relationship. Many of them have been working there for 20, 30 years and so forth. But I would submit it as a less than ideal situation. My question for you, with the 2 minutes that I have remaining, what can be done, as a former Assistant Secretary of Labor, what can be done to get more Americans working again? What can be done to reverse the decrease in the labor participation rate and incentivize and get more Americans working to fill these jobs so we don't have to rely on H-2 workers?
Congressman, that's a great question, probably the most difficult question anybody's going to be asked today. That is something that has stumped social scientists and economists and policymakers in this body and throughout the city and the country. There is undoubtedly a crisis in this country with regard to labor and people who want to work. There are some 12 million jobs available that go unfilled every month. Certainly employers who rely on these programs are frustrated. It used to be that they would get a few U.S. workers who would apply and would work part of the time or a few days and then ultimately quit. Now employers report they can't get any applicants at all. And I, unfortunately—
Where did all the people go?
It's a great question, and how do they survive day to day, and how do they pay their bills? I don't have the answer to that question. I wish I did. And I don't know who does have the answer to the question, but there is certainly a failure of policy at the local level, state level, federal level, perhaps all of the above, that has created a situation where evidently millions of Americans feel that they don't need to work. And I don't think that that's a good place for America, and it's certainly not a good place for American farms. We're at a crisis on our farms today, and it'll be another generation, and we won't produce our own food. It's going to be produced abroad because some food and some crops require hand labor. And if there's not the labor in this country to do it, it can and is done now south of the border. And personally, I'd rather have my food grown in the United States where I know what's sprayed on it, how it's harvested, and can track the supply chain. And
Well said. Thank you. I yield back.
Thank you. Representative Steele, you are recognized for 5 minutes, ma'am.
Thank you very much. According to my local chambers and many local companies need more employees, our employment rate remains very low. In Southern California, where I came from, the construction, hospitality, and healthcare industries are all in need of more employees. Every day I hear from folks in these industries that there is a shortage of qualified workers. And these industries operate year-round. The current H-2 system is not efficient for employers or those seeking to be employed. So Mr. Sequeira, if I pronounce it wrong, I'm sorry, but should Congress adjust the H-2B program to address the needs of the current economy? Could Congress establish a new market-driven plan for temporary workers to enter the United States when the economy needs them and fewer when our economy does not? Would making guest worker program visas portable help employers?
yes, Congresswoman, certainly the demand for the H-2B program far exceeds the supply of visas available. Congress has not adjusted the permanent cap on H-2B visas since it was created nearly 30 years ago. And a more market-based system for allocating H-2B visas would certainly work much better than the current system, something more along the lines of what's used in the H-2A program, where it is a market demand. As long as you can prove a temporary need and are complying with the other requirements, you can access H-2B workers when there aren't sufficient numbers of U.S. workers. The demand is easily twice the supply, 3 times the supply in the H-2B program.
So if we reform the H-2B system, including E-Verify, could the employers grow their business and fill vacant positions and add more economic activity to our economy?
Oh, I think that's undisputable. And you have seen that in the H-2A program, where many employers participate in E-Verify, utilize the H-2A program for seasonal labor. And because they have a workforce that they can count on, that they know is available, they're able to grow their businesses. And many businesses have succeeded very well and contributed to the U.S. economy and provided many more good-paying jobs for U.S. workers because there is the support of the seasonal workforce as well.
Thank you very much for your answer. I yield back.
They don't have one in the room, so I'm waiting for a committee to confirm. You can call on Takano and see if he's.
Is Mr. Takano on platform? I want to recognize.
Madam Chair, I am, and I do wish to
Yes, sir. You have 5 minutes, sir.
Thank you, Madam Chair. My question is for Mr. Pinkins. Mr. Pinkins, in your experience representing Black farm workers who have been displaced by white guest workers, do you believe that the H-2A employers are discriminating against U.S. farm workers on the basis of race, national origin, and age in their selection of H-2A workers and payment practices?
Yes, and as an example, I'll share this with you. The farming season in Mississippi begins in February and runs through November. H-2A workers are generally brought in for that time period. The entire season involves planting and harvesting crops like cotton, corn, soybeans, rice, etc. Mississippi farmers have for years, season after season, brought in white South Africans as H-2A workers without affirmatively reaching out to local Black American workers from the previous season as mandated by federal regulations. And when I say that, you have to take into consideration that the country of South Africa is over 80% Black and less than 10% white. And I grew up in the Mississippi Delta, and my work is concentrated in the Mississippi Delta. And I have yet to see a Black South African working on a farm in the Mississippi Delta. Hardworking Americans in the Mississippi Delta have been doing this farm work for decades, driving tractors, combines, and cotton pickers, planting crops in the spring, harvesting those crops in the fall. And for generations, their families worked in those fields, passing down essential skills and traditions of hard work. They know the seasons, they know the geography, they know the equipment, and they know the crops. Local community members literally know the soil in the Mississippi Delta. However, that's not the case with the workers who are brought in under the H-2A program. They arrive without an adequate understanding of the different seasons, equipments, crops. And so how do farm owners overcome this employee training hurdle? Well, I'll tell you. Many farm owners begin by finding or forcing local Black workers to train and mentor foreign white H-2A workers on how to operate the equipment, understand the season, and plant and harvest the crops. All this while the local workers who are doing the training are being paid as low as $7.25 an hour, the federal minimum wage, while the farm owners are intentionally paying the H-2A workers at least the adverse effect wage rate, and sometimes as high as $16 an hour. Next, after they have been adequately trained, the farm owners put the H-2A workers on the same type of equipment, tractors, cotton pickers, and combines that their local Black workers are operating in the same fields at the same time. The only difference is that the H-2A workers are still being paid up to $16 an hour, while local Black workers who trained them and are now working alongside them are paid $7.25 to $8 an hour. And lastly, what happens when local workers are asked for a fair raise? Everyone wants to be paid fairly for an honest day's work. When local workers ask for a raise, ask to be paid equal to their South African counterparts, one of three things happen. They are either ignored, flat out told no, or threatened with being fired.
Mr. Pinkins, I am trying to understand this. I've heard of situations where foreign workers are brought in, whether legally or not legally, and the motivation is to pay the foreign workers less. But you're telling me that these H-2A employers are paying specifically white South African workers more than the local Black workforce. Help me understand. Obviously, it's not an economic reason. You're telling me that Black workers are more qualified, more experienced, and know about the local conditions.
Yes, if a farm owner trusts the Black worker enough to train an untrained worker to harvest his crops worth millions of dollars, clearly that local Black worker is qualified to do the job. What doesn't make sense is why a farm owner would bring in an H-2A worker under a policy that says that he has to pay him up to $12.45 an hour, but still pay that local Black worker $7.25 an hour. That doesn't make sense from a business perspective. So the common denominator here is race. You want to pay local Black workers the least possible while paying white South Africans sometimes $12.45 an hour, which is the adverse effect wage rate, and in many cases up to $14, $15, $16 an hour.
Thank you, Mr. Pinkins. Madam Chair, the other conclusion that I reached is that these employers had to specifically recruit white workers in South Africa over Black workers in South Africa, if what this witness is telling me is true. I yield back.
Thank you very much. Are there other members on the platform who we have not recognized? Okay, then we're going to move on. I want to remind and thank you to the witnesses. I want to remind my colleagues that pursuant to committee practice, materials for submission to the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing. So by the close of business on August 3rd, 2022, preferably in Microsoft Word format. The material submitted must address the subject matter of the hearing. Only a member of the subcommittee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk within the required time frame. But please recognize that in the future, that link may no longer work. Pursuant to House rules and regulations, items for the record should be submitted to the clerk electronically by emailing submissions to edenlabor.hearings@mail.house.gov. Now, I want to again thank the witnesses for their participation today. It's been a very enlightening hearing. Thank you for your testimony. Members of the subcommittee may have some additional questions for you, and we ask the witnesses to please respond to those questions in writing. The hearing record will be held open for 14 days in order to receive those responses. I want to remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. We'll now have closing statements recognizing Ranking Member Keller for a closing statement. Mr. Keller, you are recognized, sir.
Thank you, Madam Chair. Also, thank you to our witnesses for appearing before the committee today. President Biden's border crisis hangs over this hearing. It's a self-made disaster that is endangering millions and creating a humanitarian crisis. We cannot meaningfully discuss reforming the H-2 programs while our border is wide open and being overrun. Employers need the ability to hire temporary H-2 guest workers when no U.S. workers are available, even though the government makes programs inefficient and frustrating to navigate. The H-2 programs are certainly in need of improvements. While the H-2 programs have extensive protections for guest workers and American workers, H-2 employers cannot compete in an environment within an unsecure border and millions of illegal workers filling labor shortages. President Biden must secure the border, build the wall, and enforce our immigration laws, which will allow the H-2 programs to operate properly and allow Congress to address the lawful guest worker programs. Thank you, and I yield back.
Thank you, sir. And let me just recognize myself for the purpose of making my closing statement. And I want to again thank our witnesses. Thank you for your time and for your testimonies. Today, we repeatedly heard the need for increased worker protections and employer accountability within the H-2 guest work programs. For too long, foreign workers have been exploited, defrauded, and abused at the hands of their employers. As I stated earlier, these programs do not reflect their intended purpose. Instead, these programs are a relic of slavery. Together, we must reform the H-2 visa program to ensure that all workers are treated with dignity and respect. And to that end, I look forward to working with my colleagues to advance several legislative proposals to prohibit worker discrimination, to protect workers from retaliation, and to strengthen labor standards. So again, thank you to our witnesses. And if there is no further business without objection, the subcommittee stands adjourned.